Now, dear friends, I come from a background where public service is considered a duty, and where privilege and good fortune demand even greater commitment to the common good. Generations of my forebears and relations established this rich tradition of public service, to which I am greatly indebted, as it is a source of constant inspiration. Indeed, Kofi Abrefa-Busia, Prime Minister of the Progress Party government of the Second Republic, and one of the great Ghanaians, said, and I quote, "We regard politics as an avenue of service to our fellow men. We hold that politics is exercised to make life nobler and happier," unquote. I'm fully aware of the responsibility the job of President of the Republic brings. I'm fortunate enough to carry a sense of the history and struggles that made that job possible, as well as being apprised of the challenges and opportunities of the future. Crucial to the progressive and prosperous future I seek to help create for the Ghanaian people is how to sustain their confidence in the democratic journey on which we have embarked. We celebrated this year 30 years of multi-party democracy under the Constitution of the Fourth Republic, which has provided the framework for the longest period of uninterrupted, stable constitutional governance in our otherwise turbulent history. Next year, we will be going to the polls for the 9th time in the Fourth Republic to elect a new president and new members of parliament. We will, in the results of those polls, witness either the changing of power from one political party to another, as we have done on 3 separate occasions in the Fourth Republic, or the breaking of the 8, something that has never happened before in the Fourth Republic. I'm sure I do not need to tell you what my present preference is. It is public knowledge. What is important, however, is that the Ghanaian people have demonstrated that they are fully conversant with the process of peaceful democratic transitions and need no lessons in the exercise of their democratic rights. Maintaining high standards and integrity in public life is key to extending our association with multi-party democracy. As one writer put it, and I quote, "Standards in public life help to maintain the health of the democratic system and uphold public confidence in it. They help prevent politicians and officials from being swayed by outside interests in their decision-making, and help to maintain a political culture that fosters open and constructive debate. They thereby contribute to a political system that is fair, inclusive, stable, and effective," unquote. The Ghanaian people are expectant that Parliament, the legislative arm of government, will continue to grow into its proper role as an effective machinery for accountability and oversight of the executive, and not be its junior partner. Parliament must stand out as an institution that represents all the values that we hold dear and in which our citizens can take pride. Our judiciary must inspire confidence in the citizenry so we can all see the courts as the ultimate arbiters when disputes arise. A Ghanaian judge must be a reassuring presence and the epitome of fairness. Ensuring high standards and integrity in public life has its own impact on the image of our nation and our ability to attract the substantial amounts of investment, foreign and domestic, needed to help grow our economy. We will attract the requisite investments if we continue to hold ourselves as a haven of peace, security, and stability. And if we continue to show that we are a country where the separation of powers is real and the principles of democratic accountability and respect for the rule of law, individual liberties and human rights are firmly entrenched in our body politic. The legal profession has a catalytic role to play in guaranteeing the sustenance of these values and thereby in helping us uphold the maintenance of integrity in the ordering of our state. Learned friends, in recent times, the debate on standards and integrity in public life has centered largely on the fight against corruption and whether or not this president and his government are doing enough to combat this cancer. It is true that corruption is not an exclusively Ghanaian phenomenon, but one which permeates all nations of the world. It results in reputational damage to businesses and establishments and undermines the public trust in governments. The manifestations of corruption are getting increasingly complex as they often occur with the aid of professional enablers such as accountants, lawyers, bankers, real estate agents, shell companies, and opaque financial systems that provide opportunities for the laundering and concealment of illicit wealth. If not controlled, corruption can stultify the economic aspirations of any nation. Globally, the World Economic Forum has estimated the cost of corruption around the world at some 2.6 trillion United States dollars a year. I accepted the invitation to speak here in order to take advantage of this occasion, to place again, once again, my government's record on corruption for public scrutiny. It will show that my government has undertaken arguably the boldest initiative since our nation attained independence, nearly 66 years ago, to reform and strengthen the capacity of our institutions to tackle corruption in the public sector. Charity, they say, begins at home. And that is why so far, every single alleged act of corruption leveled against any of my appointees has been investigated by independent bodies such as SHRAJ, the CID, and in some cases by Parliament itself. It is not my job to clear or convict any person accused of wrongdoing or of engaging in acts of corruption. That is the job of the courts and the law enforcement agencies. My job is to act on allegations of corruption by referring the issue or issues to the proper investigative agencies for the relevant inquiry and action, including, if necessary, the suspension of the affected official pending the conclusion of investigations. That is exactly what has been done since I assumed the mantle of leadership on 7th January 2017. From the allegations against the then Minister Designate for Energy, Boakye Jako, at his parliamentary confirmation hearings in 2017, to that against the former CEO of BOST, the Honorable Alfred Obeng, to those against the then two Deputy Chiefs of Staff at the Office of the President, Honorable Francis Asensu-Boakye and Honorable Samuel Abujinapo, to the conflict of interest allegations against the Minister for Finance, Ken Ofori-Atta, to the claims of extortion against the then Trade and Industry Minister Designate, Alan Chremateng, at his parliamentary confirmation hearings in 2017, to allegations of doubling in visa racketeering against the then Deputy Minister for Youth and Sports, Pius Hajije, and the then Director General of the National Sports Authority, the Honorable Robert Safo-Mensah, who, even though exonerated by the CID, later resigned. The chairperson of the board of the National Sports Authority, the Honorable Kojo Ba Ajiman, to the allegations of bribery leveled against the secretary to the Interministerial Committee on Illegal Mining, Charles Bissiou, to those involving the dismissed acting CEO of the Public Procurement Authority, PPA, ABAJ, and the dismissed CEO of the National Youth Authority, Emmanuel Esigre. They have all been investigated and in most cases cleared by the authorized institutions of the state and not by President Akufo-Addo. The latest episode involving the former Minister for Sanitation and Water Resources, the Honorable Sisidi Abna-Dapa, is evident for all to see. I am not aware of any government in the Fourth Republic subjecting so many of its officials to such investigations and inquiries. At the same time, several officials of the previous Mahama administration, such as William Matthew Tevi, Alhaji Salifu Mimina Osman, and Eugene Bafo-Boni, in the infamous $4 United States million NCA scandal, have been tried and convicted of various corruption-related offenses, and several others, including Dr. Stephen Upuni, the former CEO of Cocoa Board, and the Honorable Cassiel Atuforson, the minority leader in Parliament, are standing trial as we speak. None of the accountability institutions of state, including the new Office of Special Prosecutor, have ever indicated any pressure from the executive over their investigations. There are some who refuse to accept my method of proceeding and have characterized me as a clearing agent. Because for them, the mere allegation without more is enough to merit condemnation of the public official. For my part, I will not set aside due process in the fight against corruption, no matter how much opprobrium this incurs for me. With a clear understanding that corruption thrives in an atmosphere conducive to its concealment, and that access to information is a vital tool in the fight against corruption, my government in its first term ensured the passage of the Right to Information Act 2019, Act 989, in order to give true meaning and effect to the provisions of Article 21, Clause 1, Subclause F of the Constitution. The Act, which successive governments had failed to pass, sees to the implementation of the constitutional right to information held by a public institution, to foster a culture of transparency and accountability in public affairs, subject to exemptions necessary and consistent with the protection of the public interest in a democracy, in a democratic society. The Act is being implemented fully now, with the governing board chaired by an experienced retired High Court judge. The Ministry of Information has trained information officers in various ministries, departments, and agencies of government to support the full application of the law. In 2018, again during my first term, Parliament passed the Witness Protection Act 2018, Act 975, to which I gave assent on 24th August the same year. The Act established a Witness Protection Agency to establish a witness protection scheme as a vehicle for offering protection to persons who are required to cooperate with law enforcement agencies as witnesses in the investigation and prosecution of cases, particularly corruption cases affecting public officers. The Criminal Offences Amendment Act 2020, Act 1034, has been passed to amend Section 239 of the Criminal Offences Act to categorize the offense of corruption, previously a misdemeanor, as a felony, and to provide stiffer punishments of terms of imprisonment of not less than 12 years and not more than 25 years in prison. other laws passed by Parliament at the instigation of my administration and which have enhanced significantly the capacity of the state in the fight against corruption are the Revenue Administration Amendment Act 2020, Act 1029, the Fiscal Responsibility Act 2018, 982, State Interest and Governance Authority Act 2019, Act 990, the Anti-Money Laundering Act 2020, Act 1044, the Corporate Restructuring and Insolvency Act 2020, Act 1015, the Companies Act 2019, Act 992, including its provisions on the Register of Beneficial Owners, the Narcotics Control Commission Act of 2020, Act 1019, and the Real Estate Agency Act 2020, Act 1047. Administratively, a series of other far-reaching measures have been undertaken by my government to help in the fight against corruption. A memorandum of understanding on information exchange and collaboration in combating corruption and crime in general has been signed by SHRAJ, EYOCO, Parliament, Office of the Attorney General, Ghana Audit Service, Ghana Police Service, Financial Intelligence Center, the Narcotics Control Commission, the Internal Audit Agency, the National Investigations Bureau, NIB, and the Office of the Special Prosecutor to this end. Underlying the digitalization agenda of my government, which comprises a robust national identification system, digital property address system, the paperless port system, e-justice system, pensions and insurance data system, a digitalized land registry, and mobile money interoperability is the overarching objective to improve transparency, accountability, and efficiency in the public sector. A digitized environment ultimately helps to eliminate and prevent corruption in various institutions and agencies. The Passport Office, Ports and Harbors, Registrar General's Department, the National Health Insurance Scheme, the Driver Vehicle and Licensing Authority, which hitherto were fertile grounds for corrupt activity, are being transformed beyond recognition. The introduction of the Ghana.gov platform has significantly reduced the risk of public sector corruption through embezzlement, making it possible for services to be accessed and payments made online by card or mobile money, with a considerable reduction in the conduit of middlemen or Goro boys. It is also an undeniable fact the budgetary allocations for institutions actively engaged in public sector accountability, i.e. the Office of the Auditor General, the Judiciary, Parliament, the Commission on Human Rights and Administrative Justice, SHRAJ, the Ghana Police Service, the Economic and Organized Crimes Office, EYOCO, and the Financial Intelligence Center, FIC, have witnessed unprecedented increase since I assumed office in 2017. At the end of 2022, the budgetary allocation to Parliament witnessed a 100% increase compared to what I inherited in 2016. The police saw its budget increase by 274% at the end of 2022 in comparison to 2016. The Audit Service recorded a 258% rise in its budgetary allocation at the end of 2022 as compared to 2016. The budget of the judiciary rose by 36% at the end of 2022 compared to 2016. The budget of the Office of the Attorney General increased by 162% at the end of 2022 compared to 2016. The budget of EYOCO increased by 47% at the end of 2022 in comparison to 2016. The budget of the Financial Intelligence Center, FIC, increased by 443% compared to 2016, while the budget of SHRAJ increased by 99% at the end of 2022 compared to to 2016. These figures reflect my resolve to ensure that institutions of state of relevance in the anti-corruption agenda are properly equipped to discharge satisfactorily the mandate of their offices. In the area of investigations and prosecution of corruption and corruption-related offenses, a distinct innovation was undertaken by my administration in 2017 with a decision to set up an Office of Special Prosecutor through the passage of the Office of Special Prosecutor Act 2017, Act 959. The establishment of the Office of Special Prosecutor represents the most courageous measure by any government in the Fourth Republic to prosecute corruption in the executive arm of government. The monopoly of prosecutorial authority by an Attorney General, hired or fired by a president, had been identified by some as a key factor allegedly standing in the way of law enforcement and prosecution as a credible tool in the fight against corruption before 2017. Even though the president appoints a special prosecutor, the president cannot unilaterally, unlike in the case of the Attorney General, remove the special prosecutor from office. Article 15 of Act 959 vests the power to remove the special prosecutor in a committee established by the Chief Justice, with the President acting only in accordance with the recommendations of the committee. His or her independence of the President is thereby assured. Learned friends, inasmuch as public officials are required to declare their assets upon taking office as a tool of fighting corruption, a constitutional requirement which has been fulfilled by virtually all officials of both my administrations, I am, however, of the candid opinion that existing legislation on corruption relating to the conduct of public officers in Ghana appears to be inadequate to deal extensively with public office accountability. The need to lay down a set of far-reaching and a more fit-for-purpose set of regulations for the conduct of public officers, which will give effect to the provisions of Chapter 24 of the Constitution on conduct of public officers, is, in my view, now self-evident. The Attorney General, on behalf of government, is leading the effort to enact a law on the conduct of public officers. He has undertaken various stakeholder consultations with a number of public sector organizations, civil society, and other interest groups to this end. When passed into law, the Conduct of Public Officers Act will follow the example of legislations in other jurisdictions, like the United States Ethics in Government Act of 1978, the Public Officers Ethics Act of Kenya of 2003, and the UK Constitutional and Governance Act of 2010. In addressing issues regarding financial portfolios held by public officers before assuming public office, links to family business, improper enrichment, care of public property, professional practices, property, investments, shareholdings, and other assets, self-dealing, partiality in the performance of duties, use of public or confidential information to further private interest, amongst others. The bill will provide a gamut of stringent administrative measures and sanctions to deal with violations of the law, ranging from a bar against holding public office for limited and indefinite periods to penal sanctions and measures. The bill will also seek to strengthen the role of SHRAJ in the investigation of allegations of contravention of or non-compliance with the Code of Conduct for Public Officers, including conflict of interest, non-declaration of assets, and illicit enrichment. The Attorney General will bring the bill soon for the consideration of Cabinet and subsequent enactment by Parliament upon the conclusion of his consultations. What I have done here is to show you that my government has fought and is fighting corruption, not just in high-sounding words, but actually in concrete deeds. We have shunned mere exhortations and showy denunciations of unproved corruption. It has been a holistic approach. We have made institutional reforms, we have enacted additional requisite laws, and we have resourced more adequately the accountability organs of state. Our fight against corruption has been grounded on legislative, financial, and institutional action, and not on mere lip service. I can assure you that the fight to enhance standards and integrity in public life will continue under the Akufo-Addo government. We will enforce the law no matter who's affected, because it is a necessary foundation for the successful fight against corruption and for guaranteeing integrity in public life. The law must truly be no respecter of persons. Learned friends, I know that in some common law countries, particularly in the United States of America, the political color of judges is a legitimate topic of public discourse. Indeed, justices at the district and state levels within the federal structure of the American government are elected officials. And even though judges at the federal level, including those of the Federal Court of Appeals and the United States Supreme Court, are appointed by the President with the consent of the Senate, their political coloring is generally well known and accepted. Historically, this has not been the case in Ghana, largely because of the critical controlling role of the Judicial Council, a nonpartisan body chaired by the Chief Justice, in the process of judicial appointments. It has meant that judicial appointments are conducted essentially on the basis of professional merit and suitability. Appointments to the lower courts, the High Court, and the Court of Appeal are done by the President exclusively on the advice of the Judicial Council. In the case of appointments to the Supreme Court, because of its unique position in our judicial structure, there are the additional requirements of the consultation of the Council of State and the approval of Parliament. In the overwhelming number of cases of justices designate to the Supreme Court, that approval has been given on a bipartisan basis. You can count on the fingers of a hand the number of justices designate whose approval meant less than unanimous consent. I've gone into this matter in some detail because of a new concept that has been recently introduced into our public discourse by no less a public figure than the fourth president of the Fourth Republic, the perennial NDC presidential candidate, John Dramani Mahama. Who has told the world that I have packed the courts with so-called MPP judges, and that one of the key purposes of a putative NDC victory in 2024 will be to enable him balance the courts with so-called NDC judges. Not only are these concepts of, quote, MPP and, quote, NDC judges new in our public discourse, they are also extremely dangerous and represent the most brazen attack on the independence of the judiciary by an allegedly responsible politician of the Fourth Republic. They provide another reason, if more were needed, why right-thinking citizens should ensure the defeat in 2024 of the man whom the first special prosecutor identified as government official number one in the still unresolved Airbus bribery scandal. I'm grateful for the opportunity to contribute my thoughts to this. I'm grateful for the opportunity to contribute my thoughts to this important conversation and to the deliberations on the theme of this conference. And I wish you a successful meeting in this historic city of Cape Coast, which housed the Gold Coast Supreme Court, in which the first Chief Justice, Marshall C.J., sat. It is appropriate that it should be the venue to welcome to the Bar Conference the latest Chief Justice of our history, the 15th Chief Justice of Ghana. May God continue to bless the Ghana Bar Association and us all. And may God bless our homeland, Ghana, and make her great and strong. I thank you for your attention.